organizer that can tell me? Oh, there we go. Microsoft. Yeah, all good. Yeah. Oh, thank you. Okay. Okay, Assalamu alaikum, everyone. Welcome. And today, make sure that you feel comfortable. Feel free to sit on the carpet. I know they set up chairs, which is great, but if you want to sit on the carpet, I want to make sure everybody feels comfortable. I know it can be tiring to sit on a chair for a long period of time. But for the next hour, we're going to be discussing a pretty interesting topic. And whenever we say marriage in any topic, you see the crowds that come out, alhamdulillah, right? Because it's such an interesting topic that we're going to talk about and so important in our community. So today, my session is about preserving Islamic rights through marriage contracts and wills. The first half of my presentation is going to be focusing on marriage contracts, and the second half of the presentation, we'll take a little bit, maybe like a 10-minute break in between for questions, and then we'll talk about wills in the second half of the presentation. Just a quick disclaimer, I am a lawyer. I practice mainly in family litigation. I also do wills, but this conversation today is obviously not legal advice. If you're looking to get legal advice, you have to approach me separately. This is for information only. So, I want to start off with my presentation just asking, how many of you in the crowd are single today? Okay, how many are married? How many are divorced? How many know somebody that's divorced? Oh, of course, yeah. Quick little technical break.
Assalamu alaikum, ladies. Sister Soumia, right?
Yeah.
Sister Soumia is a lawyer, and we have requested her to come and talk to you all. She has already started, so I was a little busy. But Sister Soumia is, of course, following the time guidelines, which is really good. So everybody understands English, right? So Sister Soumia is a lawyer, and today she'll be talking about marriage contracts, and then she'll be talking about wills, and Islamic way of making your wills, and what are the different ways that it can be done. Okay, so I will now hand it over to her again. Sorry.
That's okay. No,
My apologies.
I
Sister
appreciate
Soumia.
the lovely introduction. I messaged them like, am I supposed to start at 15? They're
Thank
like,
you, Sister Soumia, for coming to our masjid.
of course.
And for giving us this amazing opportunity to learn from you. I will now hand it over to Sister. And when we do have a question and answer session, I will come around, and whoever wants to ask a question can ask. So I'm going to leave that to you, Sister Soumia. Whenever you feel like giving a break, you can do so.
Thank you.
Okay? Jazakallah khair.
So I was speaking about, how many of you know somebody that's divorced? And I think almost everybody's hands went up. For those of you who have experienced divorce or who know somebody who has experienced divorce, you know how stressful that can be for an individual. And the statistics are extremely shocking. Canada has the 29th highest divorce rate in the world. And in Canada, 40% of marriages end up in divorce. If you have, 3 kids, it's more than likely that one of them will have a divorce. You're more likely to get divorced if one person does all the household chores. And yes, this is actually a statistic. And an uncontested divorce, meaning if the parties agree to a divorce, usually costs parties $1,800 or so. But a contested divorce can cost upwards of $20,000. Think about that. That's more than a university degree. The average divorce in Canada takes about 3 years, whereas generally it takes between 12 to 18 months. But it can take a lot longer if they're fighting about issues. I have clients since 2018. It's now 2024. 6 years, and we're still dealing with divorce proceedings. Just think about how long it can take. And 34% of divorces are caused due to domestic violence, which is extremely concerning. 27% are caused by infidelity, and yes, this actually does happen in our community. 25% of divorces are a result of financial issues. No one plans to get divorced. Nobody thinks about that when they're planning their weddings. But the reality is, it's something that needs to be part of the marriage process. But there's a tool. There's a tool that exists. It can make your process less stressful, less costly, and of course, more efficient. And prenups, which is what most people think about them, or marriage contracts. Prenups is actually the American term. In Canada, we refer to them as marriage contracts or domestic contracts. They're the solution. I had this little video because when I started preparing my presentation, I went to the #1 resource for information, which is TikTok. And I just want to play this video. It says point of view when he suggests a prenup. Oh, I don't think my sound is going to play. Oh, no. It's OK. All she says is, get out of here with that European nonsense, right? Oh, look at me when I'm talking. You do not bring that European nonsense into this ethnic household, right? That's what she's basically telling him. So, of course, there's so many things that prevent individuals from even beginning the conversation at the time of marriage to even talk about a marriage contract. It's not something we think about, like, oh, you're gonna talk to him about a prenup? Really? We don't talk about that in our community. But the reality is these are just myths and misconceptions. So the first myth or misconception is I don't need a marriage contract because I love him, and we're gonna do this the Islamic way. And getting a marriage contract means you don't trust your partner. That couldn't be further from the truth. A contract essentially establishes what the two of you are agreeing on. I don't need a marriage contract because we're just only getting religiously married. Actually, if you're only getting religiously married, more than ever, you would need a marriage contract to protect your rights, because you're not even protected under Canadian law in some circumstances. I don't need a marriage contract because I have nothing. That's a huge one. Like, I don't have anything. He wants to take 50-50. I don't have anything to give him anyway. You might not have much when you're 21 years old, but by the time you're 40, 45, which is when most people end up getting divorced, you will have accumulated significant assets, maybe a matrimonial home, maybe some vehicles, maybe RSPs, a bunch of things that you could have already accumulated, and suddenly you're stuck with a scheme that you might not agree with. And marriage contracts are extremely expensive, and I'm already planning an expensive wedding. You're going to add talking to lawyers. You know how much lawyers charge. Well, a marriage contract is definitely less expensive than a $20,000 contested divorce. So what are the legal rights that come into effect once you get married? What does it really mean to become legally married? So there's two huge categories of rights that are triggered, okay? We call the first one support obligations, and the second one is about property rights. Of course, there's also rights that come about when you have children, which is rights related to the children, decision-making, and child support, but I'll focus on these specific rights. Support obligations, we also refer to it as spousal support. Spousal support is a monetary payment from one spouse to the dependent spouse when there is an economic breakdown as a result of the end of the relationship. So if one of the parties is left economically disadvantaged, they have the right to claim a spousal support payment from their former partner. There's three types. There's a compensatory spousal support. Compensatory spousal support means by nature of the traditional roles that you have in your marriage. One partner might be working outside the home, the other partner may be taking maternity leave, taking care of children, and their career kind of stagnates, right? They stop working to take care of children. The other partner's career goes up. And so at the breakdown of this marriage, one partner, if they suddenly go back into the workforce after not having worked for 10 years, they're not going to make the same level of income as their partner who has been increasing and improving their career over the last 10 years. That's why we call that a compensatory spousal support, which is you pay a certain monthly amount based on your income. Non-compensatory is for long marriages. For example, a 25-year marriage, where by nature of the marriage, you're used to a certain lifestyle. You're used to living in a certain way, type of home, type of luxuries. And as a result of the breakdown of the marriage, you suddenly don't have any of these things. So just by virtue of the marriage being so long, you might be entitled to a non-compensatory spousal support payment. And the final one is a contractual. And contractual is what individuals agree to, whether it's during the marriage, after the marriage, or prior to the marriage. The next huge category of rights is ownership and division of property. And the first one is equalization. And many of you might say, well, that just means 50-50. Upon marriage, everything is 50-50. Not exactly. Equalization means the equalization of the parties' respective net family properties. And that sounds like a huge word, right? Let me kind of break it down. When we talk about net family property, we talk about your net worth. Your net worth is what you own at the time of separation minus what you owned on the date of marriage. So let's say, for example, you got married at 18 years old. You have $0 in your bank account, but you get separated at 50 years old, and you have $500,000 in your bank account. Your net worth is 500 minus 0, right? Sometimes people come into the marriage with something. Maybe you come into the marriage with some savings, $50,000, and at the end of the marriage, you have $150,000. 150 minus 50, you're worth 100. Same thing with your partner. They would have a value at the end of at the time of separation, which we call the date of valuation, minus what they own on the date of marriage. Whoever has the higher net worth owes 1/2 the difference. That payment is what we call an equalization payment. So it's not 50-50, it's an equalization of the parties' respective net family properties, which results in an equalization payment from one party to the other. And it's not necessarily male to female. It could be female to male. So when we talk about it in terms of the Islamic concept, most of you are like, I am not giving him a penny. That's not in our religion. But it's really important to solidify that if that's your intention when you get married. The second one is the division and possession of a matrimonial home. Matrimonial home means the property that the parties individually resided during their marriage. So they occupied it as their family residence. And it's usually where they live with their children. It may be more than one property. They may have a cottage as well that they ordinarily occupy throughout the whole summer. It could be multiple properties. That property, regardless of who owns it, is always 50-50. So imagine somebody might come into the marriage with a property. Usually, let's just say the husband is coming into the marriage with a property. The day you get married and you move in, that's 50-50. Even if he pays all the mortgage, even if he pays all the down payment. So there is an interest sometimes through marriage contracts to protect assets that you come into the marriage with. It could be your home. Let's say you inherited a home, and that home becomes a matrimonial home. All of that can trigger certain rights that you might want to protect through a marriage contract. So the marriage contract can outline what you want to do with spousal support, what you want to do with, and what you want to do with property division. So that falls under Section 52 of the Family Law Act, which gives individuals in Canada the right to enter into contracts between themselves irrespective of what the Canadian law states. So you have the right to say, I'm not going to follow what I'm entitled to under the Family Law Act, the division of property or support obligation. I'm going to contract into what I want. I want a mahr. I want maintenance during my iddah period. I want this, I want that. Whatever you agree to Islamically, you can contract into that and contract out of what the Canadian law entitles you to. So there's a few ways you can do it. You can enforce. Some people will say, well, I actually agree with the Canadian law. I want that in my marriage contract, in addition to my Islamic rights, right? Some people might want that. So you can put that in your contract. You can modify your rights, or you can absolutely waive some of those rights, okay? The only things you can't really contract about is children, because the test for children is what is in their best interests at the time of separation. And it's impossible to predict what's going to happen in 5 years, and how many children you're going to have, and who's going to have the right to decision-making over those children. We do that analysis at the time of a separation, okay? So there's no way that we can contract into it prior, and you cannot contract out of child support, okay? So I know Islamically, for example, the men are always supposed to support their children, but in Canadian law, that is not gender specific. It's about the right of a child. It's not the right of the person to receive child support. So whoever has primary care of the children would be the recipient of child support. So let's talk a little bit about spousal support. Spousal support is determined in accordance with the Spousal Support Advisory Guidelines. So these are kind of guidelines that the government has placed. You enter the person's income, you enter the spouse's income, and a calculation is going to come up and tell you what is the monthly amount of spousal support that's going to be payable. And it's not, it could be, $5, it could be $4,000, $5,000 a month, depending on the parties' respective incomes. So you can choose in your marriage contract to limit when spousal support can be paid. So for example, some individuals will say, well, if we were married only 2 years, there should be $0 of spousal support. Spousal support should be waived. But if we're married between 2 to 5 years, we can agree that I'll pay spousal support for a year, okay? So you can limit how long spousal support would be paid for, depending on how long the marriage lasts. You can also limit the quantum, which is to say, well, maybe the spousal support advisory guidelines say I have to pay $1,500 a month, but we both agree that I'll never pay you more than $900 a month. You can agree to that. Or you can say, we don't believe in the spousal support doctrine, so neither of us are ever going to claim spousal support from the other now and forever, and we're going to waive all rights to it. Same thing with property division. You can say, I agree to sign up to the equalization regime, or you can say, I'm going to modify it. I'm going to exclude certain properties. I'm coming into the marriage with this property. You'll never have rights to this property, because this property, I'm the one who paid for it. Even if it becomes a matrimonial home, you won't have any rights to it. Or you can agree to divide only certain things. So for example, you say, we're only going to divide these certain assets. We're going to exclude this property, we're going to exclude my business, but we'll divide my pension or my RRSPs if they grow over time. You can choose and pick when you're creating a marriage contract. You'll sit down with your lawyer, they'll go through your assets, and you can decide about what you want to protect and what you don't, okay? Or you can choose to simply waive equalization and say, we're never going to divide according to equalization. We're only going to divide according to ownership. What's mine is mine, what's yours is yours, what's registered in both of our names and is joint, we're going to divide 50-50. You can also agree to that. The matrimonial home, slight thing, there's two things you can't really contract out of, which is the right of possession. So even though you can contract about who owns the matrimonial home, how it's going to be divided, there is a specific right that you cannot kick out a person from the matrimonial home. And that's really to preserve rights and prevent abusive contexts where somebody suddenly is left out into the street with children just because they're not entitled to a matrimonial home. Sure, you can waive rights to ownership and the finances of that home, but kicking a person out of the matrimonial home is not something you can contract out of. What makes a marriage contract enforceable in Ontario? It must be in writing. You can't have a verbal contract at the masjid in your nikah in front of everybody and say, this is what we agree on, we're going to live by the Quran and Sunnah, and that means that's our marriage contract. That's not an enforceable marriage contract. It has to be in writing, and it has to be signed by the parties, and it has to be witnessed by each person's signature has to be witnessed. And that's really important when it comes to ensuring that the parties' intentions and understanding of what they're signing up for is solidified in an agreement. The second thing is there has to be an exchange of financial disclosure. You have to know what you're signing up for. So many people get married and having question marks about their partner's financial situation, the debts they have, the assets they have. When you enter into a marriage, everything should be crystal clear. You know their financial situation so that you can make an informed decision about what you're waiving, what you're agreeing to, and what you're modifying. The third thing we call it is the obtaining independent legal advice. Both individuals will obtain legal advice from their own lawyers and understand the rights and obligations that they have under the contract that they're agreeing to, and they'll each sign it. And the last one is the absence of pressure, or what we call duress. Somebody can't be putting a gun to your head and saying, sign this contract. Usually that doesn't happen, but what does happen is somebody will show up with a marriage contract 1 week before the wedding and say, sign this or we're not getting married next week. That creates pressure. Marriage contracts need to be thought of in planning the wedding. When you're picking the hall, you better be picking your lawyer, right? About who's going to write your marriage contract so that you know what you're signing up for. There's cases where marriage contracts are set aside, and that means the courts don't look at them anymore. They're unenforceable. So if you fail to disclose significant assets, for example, if you own a company and that company is making a lot of money and you don't disclose how well your company is doing, and your partner now says, it's okay, I don't want any rights to your business, I'm agreeing to exclude your business from any equalization, suddenly that partner felt like they were duped, right? Because they could be entitled to thousands of dollars and suddenly they waived all rights to your company. So if you fail to disclose significant assets, it could be a ground for a court to say this contract is not enforceable. Another way that contracts have been disputed or challenged in the courts is where a party failed to understand the nature and consequences of a contract. That might happen where somebody says, I don't need a lawyer, I trust you, you drafted it, it's okay, I'm not going to get a lawyer. Red flag. That makes your contract really hard to say, well, they knew what they were signing up for. The average person doesn't even know what equalization means or spousal support. They need to learn and understand what their rights are before they can waive them. Okay? And there's fraud, duress, undue influence. That might be pressure from a parent, pressure from the spouse or fiance. And sometimes signing too close to the marriage date makes that marriage unenforceable. When clients contact me and they say, I'm getting married Saturday, I say, congratulations, but you need a post-nup. You don't need a prenup. I can't do it in a week. It's too hectic, and your partner is going to feel pressured into signing that contract. So let's talk a little bit about the Islamic law, because now I've kind of given you the background of what Canadian law says, but what do you want to see, or what do I usually put in Islamic marriage contracts? So we have to talk about what does it mean to be legally married and Islamically married. When you're Islamically married, you usually have, a nikah or kitba kitab. There's many different cultures say different words, but the Islamic marriage where you have an imam, you have the witnesses, you have the wali, that's what are the conditions of the Islamic marriage with the exchange of a mahr and the consent of the bride, right? Once all of those are in place, then you're religiously married. The legal marriage, there's a marriage license, you sign, and that's filed with the government so that you are now legally married. The legal marriage is what triggers those rights. Sometimes individuals will do Islamic ceremonies, and the Islamic ceremonies, courts have found if they're legitimate enough, even if they don't sign that marriage license, they recognize that as a legal marriage, because then they portray themselves as husband and wife to everyone, they purchase assets together, they live together. Because there's a difference, right? In Canada, you can be in what's called a common law relationship, which is we agree to live together, but we're not married of any sort. And common law spouses don't have any rights to property. Legally married spouses have the rights to property, equalization, etc., right? So sometimes it's in an interest when there's an Islamic ceremony, one of the spouses says, actually, I want property rights, so they want the government to recognize their Islamic marriage as a legal marriage. it's a process, right? The best way is just to get your marriage license and register it with the government. You don't want to be fighting about whether your contract is legal or religious, right? You want to be clear, is this a religious and a legal marriage, or is it one or the other? Most imams in Ontario who are registered marriage officers will not do a nikah without the legal paperwork because they want to ensure everybody understands what they're signing up for. Another thing that you absolutely, I almost always see in every Islamic marriage contract I do is the mahar. And that's because there's two types of mahar. There's mahar muqaddam, which is usually given at the beginning of the marriage, and some will have a mahar mu'akhar, which is a delayed or deferred mahar that's paid at a later time upon the wife demanding it, or it's paid at the time of separation, or from the estate of the husband if he dies before he pays out the mahar. So the mahar is one of the biggest challenges that people have because one party is not going to want to pay it, which, you know, once the breakdown of the marriage, they're going to say, well, I only agreed to that under certain circumstances, and suddenly there's one party going to court just to have their mahar paid to them. The Canadian courts have recognized mahar contracts, but they need to be in writing, they need to be witnessed for that. It cannot be just a conversation in front of the imam, yes, we agreed, and then suddenly one person says 5,000 and somebody says 50,000, right? It needs to be written out. Other things I've done or I've written in marriage contracts is the wife having the right to initiate a divorce, the right to have maintenance during the iddah period, which is once the husband pronounces the talaq, there is a period of 3 menstrual cycles. They want to ensure that the husband continues to support them during that time, or if they're pregnant, until they give birth to the baby. And very often, more likely than not, many people write clauses about polygamy and the husband not having the right to take more than one wife, even though it's illegal in Canada, so it should not happen anyway. But people have requested that you cannot legally marry two spouses in Canada. So people will just write they're not allowed to be currently married without telling me or take on another wife without my permission, etc. So I've gone through most of these. Keep in mind, the Islamic marriage does not need to be on paper. It just has to be verbal, whereas the Canadian legal marriage has to be on paper. Okay? So I talked a little bit about common law spouse. And I kind of want to talk a little bit about why that kind of makes it difficult. So in certain cultures, many individuals have what's called, the nikah or the kitb kitab, and they say we're engaged, right? But they're really Islamically married, but they refer to themselves as engaged because they don't live together until a certain time, until the wedding or the rukhsati or the night of the wedding, right? So the period from the time they have their kitb kitab to the time that they get married might be a year, it may be a year and a half. So legally, during this time, they may be legally married, but they may not be cohabiting together, right? Or they may be Islamically married, not living together, but they already purchase assets together. They may, get a mortgage, get a pre-construction property. That triggers these rights, but they're not protected because they're not under the legal marriage. They're only Islamically married. And remember, common law spouses don't have rights to property. So it creates that foggy field, which is why a marriage contract would be essential at the beginning of that step. Okay? So I won't go into too much detail about the mahar in Canadian courts, but it has been recognized, which is a great step because the original cases did not recognize the validity of mahar contracts, but there was a Court of Appeal decision a couple years ago, I believe it was in 2007. It suddenly recognized the enforcement of mahar contracts, but again, they have to be witnessed and in writing, and there needs to be a clear intention of what the parties contracted into. There are clients as well that talk about the religious divorce. and they kind of want to spell it out in their contract. How are we, if we do break down this marriage, you're not going to say talaq 3 times in a row and end the marriage, because that can be very stressful. Then there are people sometimes feel remorseful and they didn't mean it, etc. And then they're all going to imams, and then there's halala and all this stuff, right? So they say, no, we're going to do it the Islamic way according to the sunnah. So I want you to say the divorce. If you want to divorce me, then first we're going to have a list of conditions. We're going to try marriage counseling for 6 sessions. We're going to try to involve an imam to help us resolve our affairs. If we don't agree, then you can pronounce the talaq, but then you have to wait 3 months before you pronounce the second talaq. So you can list out all of these rules and requirements. We have to try dispute resolution in order to save your marriage. And it's better to do that in your marriage contract so that both of you agree as to how is the process going to be if we don't agree. Are we going to try to save our marriage? Nobody just wants to go straight for a divorce, right? They want to try at least put in the steps of dispute resolution and negotiation to save that union. Okay? A lot of individuals will talk to me about importance of iddah, support during the iddah. Now, with that said, while some people agree to, the 3 months, you can agree that yes, you're going to support me for 3 months for the iddah period, but I also want extra, right? Maybe you'll support me for 2 years because I plan to stay home and take care of children, and we plan to have children right away. You can contract into that. There's nothing wrong with asking for more than what you're entitled to under Islamic law. There's nothing wrong with even contracting differently than what the government entitles you to, okay? So as long as you two agree to those clauses, you can enter into that contract, okay? Now, it's really important to put in your marriage contract that the mahr is not a replacement for support. The mahr is its own category. It's a gift from the groom to the bride, and it's a condition of the Islamic marriage. It's not supposed to be your support payment during your iddah period. They're completely different. Now, Canadian courts were kind of confused because some of them say, well, if you have a high enough mahr, that means you have enough support. But if you have a marriage contract, that would clarify to the Canadian courts, they're completely different, right? Because the way the Canadian courts have treated mahr is that they've included it as part of your net worth, right? So suddenly you're worth more money because he owes you a mahr amount. And that's usually when I talk about that, I mean deferred mahrs that have not yet been paid out. Okay? Okay, so any questions about marriage contracts before we take a little bit of a break, and then we'll come back and we'll talk about wills. So I think, do you want to? Walaikum salam. Thank you. Oh, I don't think it's on.
Everyone, thank you for coming and joining us. I will request you all to take a break. Meanwhile, she's answering your questions. Some of you can start taking snack. There's a tea, coffee, and a little bit of snacks. Please help yourself. We have a 5-minute break, and while a sister can answer your questions.
I think we had a question over there.
Sisters from the first row, can you please start?
Assalamu alaikum.
Walaikum salam.
So for the spousal support obligations under Canadian law, how long does that usually run for?
The spousal support?
Yeah.
It varies on the length of the marriage. So if you have a marriage, maybe less than 10 years, the spousal support may be for like 3 to 5 years. But if you have a marriage for 10 to 20 years, it may be for 15, 16, 17 years. If you have a marriage that lasts longer than 20 years, almost always, the spousal support is indefinite. That means for the rest of your life, which is very concerning to some individuals because imagine having to pay spousal support on top of trying to create a new family.
Yeah. Thank you.
Assalamu alaikum.
Alaikum
I wanted to ask about the meher. So you said that it has to be written, and can that also be part of the marriage contract? The meher portion?
Yes, so you would, in your marriage contract, you would write out what are the terms of the mahr. So some people will say, well, we're going to have an upfront portion, $2,000 and a gold set at the beginning of marriage, but I'm entitled to a deferred mahr, And in some cultures, it's extremely high, the deferred mahar. It could be upwards of 100,000. Sometimes it's like 100 British gold coins. There's different values. But let's say you agree to $10,000 payment, a deferred payment. Some people will actually say it's going to be paid starting the 3rd year of marriage at this interval. Or some people will leave it blank and say it's to be paid upon demand by the wife, upon divorce, or upon the death of the husband from his estate. So you can lay out all the terms, and I would say in your marriage contract, you would say it's also excluded from the net family property. It has nothing to do with property. It's a separate financial obligation from the husband. And I would say it's not a replacement for support. So that all goes into the marriage contract so that you actually get the full amount of your mahar. And it's like any contract. It's like your contract with Bell when you purchase a phone or whatever. You have terms of the payment, and you're going to have to pay them regardless of what happens. It's not a substitute for a data plan or something like that. You're paying for your phone. You're paying for your phone.
Yeah, so I was thinking, like, when can the marriage contract be done? Like at the beginning or even after the marriage?
You can do them at any time.
Okay.
Anytime. So remember, the American term is prenups, but in Canada we refer to them as marriage contracts, right? If you do a marriage contract before a wedding, we usually do them 3 months in advance. That's when we start, and they're signed off at least a month in advance or 2 months in advance of the wedding. But sometimes individuals just don't have that time frame, or they don't have the money, or they didn't think about it. You can do it after you've gotten married, but all those factors have to be put in place. You exchange financial disclosure, you obtain independent legal advice, you are not being pressured into entering into this contract, and then you agree and make a marriage contract, but it's post-marriage.
Assalamu alaikum.
Actually, if khula taken by a wife, so what would be the property distribution?
If the khula is taken by the wife, what would be the property or the mahar? The
Property.
property? So legally, right, anyone can file for divorce, okay? It doesn't matter who starts the Canadian divorce. The rights are there. Islamically, there's different rules if the wife initiates the divorce versus if the husband initiates the divorce, right? So if you enter into your contract that says it doesn't matter who starts the divorce, whether it's a khula, whether it's a talaq, I'm entitled to this mahar no matter what, I'm entitled to property division no matter what, that would be in your contract. Even the support. But if your contract is silent, the court doesn't read things into it. They're not going to do a religious analysis. That's not their job, and it's beyond the scope of the court, because Islamic experts, everybody will bring their own experts to say something different. They really focus on what's within the four corners of that contract. If they don't have a contract, what would happen? It doesn't matter, right? If there's no contract, the Canadian law applies, and the Canadian law is no-fault divorce. It doesn't matter who starts the proceedings. Yeah. I'm so sorry, I can't hear. The mic is right there.
Can you yourself one question and then we'll come back? Because we'll come back to your question. Thank you.
Assalamu alaikum. I
Walaikum
just had a
salam.
quick question because I've only been a revert for 6 months, so I'm not looking.
Oh, mashallah, revert for 6 months. Thank you.
Okay.
Put it closer.
Okay, but like I'm not like saying I'm gonna get married tomorrow, but how do you actually like bring this up with somebody? Like, do you have in your experience couples where they're just like, okay, we're just gonna go and like, you kind of are the medium between like starting the conversation, or is this something we should talk about before we like would book an appointment?
Yeah, I find that actually most couples that I've done marriage contracts are, when one person brings it up, the other person is actually like, oh, yeah, I'm willing to look into what this is about. Yeah, of course I want to Nobody has ever really reacted negatively. And I think the negative reactions are more from cultural stigma or taboos. I have had couples who say like, I don't want to involve my parents in this process. They'll never agree with this. If they knew I was talking to a lawyer, they would be so upset. But the reality is, it should be a family topic, it should be a family conversation, and to say, what's wrong with putting down what we're agreeing to? There's nothing wrong with that. Actually, it helps everybody clarify what their rights and obligations are. And I think the easiest way is to say, Canadian law is so messy, I don't even understand half of it. How about we just like enter into an Islamic contract and I really just want to write something Islamic, right? If you say it like that, your partner is more likely to be receptive to that and say, of course, I want to start my marriage according to the Quran and Sunnah, and then find lawyers that can assist you with that process. So kind of starting it from like, I don't really know what my rights are, even though you know everything today, after today. But you say, I don't really know what my rights are, I really want to understand what we're signing up for. And I think some of it contradicts what our religion says, you can say that. And just try to approach it that way from an informed way. You're welcome.
Assalamu alaikum.
Speak into the mic.
Assalamu alaikum.
Wa alaikum salam.
Actually, the one of the slide which mentioned that what is a Canadian marital contract. It seems like I'm not so sure, but nikah nama kind of fulfill all those things. But I've heard before that it's not. I mean, if we show a nikah nama for a meher or something else, whatever is written in the nikah nama, it's not considered legal. For Canadian marital contract, is that true?
So if the nikah nama is signed and witnessed, and sometimes I will see a nikah nama and it will say bride signature, groom signature, wali signature, imam signature, 2 witnesses, mahar $5,000 to be paid, whatever. That's a legal marriage contract. But the problem with that contract is it doesn't say anything about equalization. It doesn't say anything about spousal support. And more often than not, what the courts will say, well, the mahar then falls into as part of your property. But Islamically, the mahar for us is a completely separate topic. It has nothing to do with property. It has nothing to do with maintenance. So that will basically make your mahar as part of your property, which could nullify your mahar depending on your net worth, your husband's net worth, etc. There's I can't really do the math for you right now, but ultimately it doesn't protect you from the other rights that you're trying to maybe waive or enter into or modify. But as long as it's signed and witnessed, it is a contract of some sort. Okay, I'll take a quick 5-minute break, and then we'll come back and we'll talk about wills.
Sister Soumia, will you be taking questions later? Because I have a couple of...
Yeah, I have my last slide says questions. So,
yeah.
And I'm here,
so we'll get back to these later.
Yeah, of course.
Jazakallah khair. I can also take a samosa. Hey, I brought the hummus and I'll try that. Corona. Sara, तुम भी ले लो. अभी ले लो, break है ना? No. I can see them. We had all that. That's all. That's all. I got it. हाँ वाकई
बस जो हो जाए वो
माशाल्लाह।
इतना प्रायोरिटी नहीं है, डालती हूँ
हाँ,
जो आ जाए
अच्छा
है,
है।
अदरवाइज नहीं।
वेरी
That's
नाइस।
not a personal tax. Personal tax करती हूँ। आपने पूछा नहीं? आपने पूछा? मुझे लग रहा है किसी ने पूछा।
सबीना।
मैं ले लूँ, पकौड़ा ले लूँ?
हाँ जल्दी से ले लो, ख़त्म हो रहा है। सारा ले लो।
पानी वो जो फाउंटेन
हाँ हाँ वही है। I'm going to eat mine stuff later.
क्यों कंफ्यूज कर रही है सबको?
मैं ये कह रही हूँ, बोलने के लिए तो करती है, आई नहीं।
हाँ ऐसे करती है। अब सामान लेके जाना है
We
तो
do all the
मैंने अभी
Shahin and I.
I know I trust you too only.
Thank you. मैं सबसे पहले आई थी।
Called her कि I trust you
and
I want you to be there. फिर आपने कहा मैं आ गई ना।
बिल्कुल of course।
लेकिन
वही मैं
फोन
बोल
नहीं उठा
रही
रहे थे,
हूँ।
मुझे इतना स्ट्रेस था, मेरा फोन कोई नहीं उठा रहा था। Anyway, मुझे उम्मीद थी हो जाएगा, बस फिर भी स्ट्रेस।
भाई ये टेबल ये सब ये मैंने उनसे लगवाया, आदमी से एवरीथिंग चेयर।
अब मुझे था कि आदमी अभी 8 बजे तक बाहर काफ़ी लेना है आपने।
अब वो भी मैंने करवा दिया था announcement, everything I took care of it. But
आप बोले ना कि मैंने
मैं भी
बोला
बोलती
volunteers
हूँ।
तो सारे adults हैं, they can help themselves. They will agree and there is no work. Okay,
सारा ले लो। कहाँ जा रही हो? नहीं है ना ये। It's okay, सुनो। Don't worry, don't go anywhere. सारा there's no need. लेकिन listen to me ना, जैसे ना, लेकिन लोग भी तो खत्म हो गए। Everybody's had their drink. You'll just do an effort for no reason. कौन कह रहा है तुमको? Forget it now. She's going. Sada has told her to go get drink.
Oh no, please.
Yeah, and I'm telling her no. अच्छा वो सही है। I thought you were leaving the masjid. No, that you don't do, okay?
नहीं, उसको कहो कि she can help herself. अपने लिए चाहिए उसको।
अरे है अभी।
Yeah, this is my bag. Sarah, I don't know what word should I use it. Don't be so polite.
She doesn't know yet. अभी इसको पता नहीं ना. Anyway, this is my plate. Please don't throw it. सॉरी सबीना सारा, ये मेरी प्लेट है, फेंकना नहीं।
नहीं, मैं इसलिए आगे लाइसेंस नहीं करी क्योंकि मुझे ना ग्लूटेन की एलर्जी है। तो मैं शाही के अलावा सॉल्ट ले नहीं सकती।
वो ठीक है। Yeah, sure. बोलो. Of what? So that's it. Okay, fine. Oh, I've been telling her कुछ ले लो.
Nice event.
Thank you.
It's my first time coming to a sister's event. So
Oh really? Yeah. Thank you.
usually I'm working, but alhamdulillah, it's
You
really
should
nice.
come. We have so many. And
Yeah, I always see it on
we
Instagram.
always have them in the evenings, so working people can come because most of us are working anyway.
No,
What's your
that's
name?
good. Fatma.
Welcome, Fatma.
Yeah, thank you so much.
Sara, तुम वो तो लो.
छोटे वालों से थोड़ा डर रहे थे, अपसेट हो गया।
Yeah.
Whose is this? और ये तुम्हारे लाओ. Take your. What is wrong with you? Come here.
Maybe you said like 3 years, maybe 18 months. So
Yeah, Khula.
Come on, you have to
Yeah,
have
Khula
this.
is a separate process. It's Islamic process, right? So usually the Khula, they will get it from an imam. They will contact an imam who will do the investigation and try to get a Khula,
Sarah.
or they will issue the Khula
Okay, so
for the
drink
wife.
tea. Ye lo. There is tea in this and it's going to finish and I want you to have it because you're not taking anything.
No, that
I'm so
still
sorry.
is alive. Whether you're Islamically divorced doesn't stop your legal rights from being in place. So many people may be already Islamically divorced, but they're still going through the process legally. Yeah, but it doesn't mean that your Islamic divorce is like held captive, right?
But the thing is, I have a big issue here with my sister, and he wants to get married, and he doesn't want her to. He wants my sister to date his
Nikah.
nikah. But he doesn't
She can reach out to the imam to assist her with the khula process.
But she doesn't want that to be done to him second marriage. But he will pressurize
Yeah. Yeah, yeah, I can definitely assist her. Yeah. Yeah, I'll give you my contact info. It'll be on the last slide. Yeah. Okay. Okay, I hope most of you had a chance to get some tea and coffee and some snacks. I'm just going to resume because it is getting a little bit late, and I'm going to continue with the presentation.
Yes,
but
ladies.
Feel free to grab, continue finishing grabbing your snacks. Okay, so I'll talk a little bit about wills. So again, there's a legal.
Please sit down, sisters, after taking your snacks.
Thank you. So again, it's a legal disclaimer. I just have to do that because the Law Society mandates that I do that. But again, this session is information. It's not specific legal advice to any of you. If you need specific advice about your wills and your estate situation, you need to contact a lawyer. So I'll talk a little bit about the agenda with respect to wills. And this part of the presentation will be a little bit shorter than the marriage section. We're going to talk about what's a will, how does one go about making a will, the types of wills people can make, the limitations of wills, and especially Islamic wills, what are the limitations of having those done in Ontario, and finally what happens in the case of intestacy, which is when someone dies without a will. So what's a will? A will, it's a legal document, and it only comes alive at the death of the testator, which is the individual who makes the will. It basically only has any power when it's attached to a death certificate. It has to be in writing, and it lists executors, beneficiaries, and guardians. Executors are the individuals who are in charge of administering the will. So they're the person who are going to take your will, they're going to arrange the funeral, they're going to file your last tax return, pay off your creditors and your debtors, and then they're going to divide the assets or the residue between your beneficiaries. The beneficiaries are the individuals who are receiving a benefit, which means they're the ones who are inheriting from your will. It could be an executor as well, but more than likely it's more than one person. Okay? So Islamically, the beneficiaries are your children, your spouse, your parents. If you don't have children, it may be your parents, etc. There's different rules. There's different charts and percentages in an Islamic law. In Canadian law, you can do whatever you want, right? Which is you can say 100% to this person, you want to leave everything to charity, whatever you want to do. So a will, for it to be formal, it doesn't really necessarily have to have all the legal jargon, right? It can just say, here's my executor. If this person's not available, here's my second executor. Here's how I want my things to be divided. And here are the powers I'm giving to my executor. It doesn't necessarily need to say, herein is my last testament. And you know how lawyers write. That's our fancy writing. We do it for you like that because it's fancy. But it doesn't necessarily need to be like that. It needs to identify who is the testator, which is the person making the will. And it needs to be the last will. So you need to say, if I made a previous will before, I revoke it, and this is the last will. So they'll usually check dates. If somebody has more than one will, the latest one is obviously the most recent will, although most people will destroy former copies of their wills. Okay? It needs to have witnesses. There needs to be 2 witnesses for a will who witness the testator sign off on the will that they're signing. Okay? A beneficiary cannot be a witness. So you can't bring in your spouse or your child if they're your inheritors. They cannot be the ones who are the witnesses. Most people will do it at a lawyer's office and have the lawyer and a staff member at the lawyer's office or friends that are not inheriting under the will to be the witnesses. You also need to list guardians. If you have minor children, what would happen in the event of the death of both parents at once, which could happen. People can travel, both of them die in an accident. What's going to happen with the children? Who's going to be the guardians of those children? And finally, if there's changes to a will, sometimes you want to update, maybe somebody passed away and you don't want that person to be the executor anymore because they're no longer alive. You might want to do a codicil, which is basically to say this is an appendix to this will that I signed on this day. I'm changing the second executor to this person because they've passed away. Okay? You can't go and cross out and write XXX, Soumia gets everything, right? You can't do that on a will. That's not gonna work. You need to actually do it, formally have that codicil witnessed by 2 people, etc. Okay? Or you can just destroy the will and write a new one if you're making changes. Okay? So when you execute a will, you'll have individuals sign on every single piece of paper because, again, you don't want somebody inserting a piece of paper saying Soumia gets everything. That's not going to work, right? Every page needs to be signed, initialed, and the last page is signed, okay? And one of the witnesses is going to swear an affidavit that they saw you sign in the presence of the other witness. And that document, the affidavit of the will witness affidavit, is one of the most important documents. If that is lost, you're going to have to find one of the witnesses who saw the will and swear a new affidavit that they saw you back in 1980 sign this will. Okay? Executors, they have to be over 18 years old. So sometimes parents will say, I'll put my spouse first. If not, it's going to be one of my children, provided they are 18 years old and above, okay? It's preferable you obviously get this person's consent. Being an executor is not a one-day job where you go to a lawyer's office and sign off. It's a 1 to 2 year job, basically, on top of your additional work, where you have all these additional responsibilities in administering an estate. It's hectic, it's time-consuming, there's a lot of appointments, there's a lot of talking to banks, liabilities, paying off, it's a lot of responsibility. So you want to make sure the person that you're putting on your will consents to take on this role for you, okay? Don't just assign people and take people by surprise. Preferably it's somebody younger than you. Of course, we don't know when anybody's going to die, but the rule of thumb is usually someone with a longer lifespan. You don't want to put, an elderly person as your executor and they might predecease you and they're no longer there. We usually have backups in the will, so you'll write this person is the executor. If they're not available, this person. If they're not available, this person. So you do have some backups, but just preferably somebody younger than you. They don't have to be a Canadian citizen, but they don't have to be a Canadian citizen, but if they do, they may have to purchase an insurance bond, okay? Which is an additional step. They might need to travel to Canada. It's just really hectic to assign somebody who doesn't live here, okay? And it can be a family member, it can be a friend, it can be a beneficiary, it doesn't matter, but make sure that they're up to this task. Okay, there are what we call holographic wills, which is, somebody who's on their deathbed and takes a piece of paper and says, everything I own to my spouse and my children, and they sign it. That actually has been recognized as a valid will because they have written it in their own handwriting. But stick to the proper way of doing it, which is through counsel and doing it formally with the will witness affidavit and not relying on a piece of paper that may get lost, may get wet, and some of the writing may get written off. So it's not consistent, or it's not recommended to just write out your own will in your own handwriting. It might get lost, etc. Okay, and also from an Islamic perspective, I don't know if that would even be valid to have a handwritten will like that without even checking. You'll see a lot of people will ask me about these pre-printed will forms. And you might have seen some websites that say, we do Islamic wills, pay $99, and you just go on a website, you enter your Islamic heirs, and then it pre-populates a form and you sign it. As a lawyer, I highly do not recommend those softwares, not because I want your business or anything like that, but just really because you're signing onto something and you have no idea how to plan your estate. You don't really know what your rights are. You don't really know what are the limitations of that document. And you're basically signing a contract or about how things are going to be managed after your death without receiving advice about how to manage things after your death. When you talk to a lawyer, we'll go through estate administration tax. We'll go through how to plan your estate and divide your estate in order to minimize taxes. There's a bunch of things that we will do to talk with you that you wouldn't get from a pre-printed software. I highly recommend doing a formal will. And someone told me a long time ago, and I'm sure many of you probably know this, like there's 3 things that Muslims should have: a will, the white shroud, and the land of where we're going to be buried purchased. And I think most individuals don't even have a will. And it's more than ever important in our society to have a will, especially if you want your assets to be divided Islamically. So what makes a will valid? You have to be over 18. You have to have the capacity. So even if you're over 18, some individuals don't have the mental capacity to have a will. That will would not be valid. This was actually, if you get married previously, it would nullify a will that you made pre-marriage. They recently amended the law, and that's no longer true. So even if you get married, a past will would still continue, but you would obviously want to update because as soon as you get married, you have a new Islamic heir. And obviously there's concerns about undue influence, or especially for elderly individuals. Sometimes I'll have elderly individuals come to my office and I'll have their children, and their children are sitting outside and they're like, you better write this, and that's not happening, right? I will not meet with children. I will not have the children present when I meet with an elderly person, because you want to make sure that this person has the capacity, understands what's happening. So that's why a lot of wills get challenged that are written on the deathbed, where one of the children is like, here, leave everything to me. I'm the one taking care of you, right? And I'll continue to take care of your assets. Those wills are often the most challenged, okay? So a will doesn't deal, so whatever forms part of your will, that's what we call your estate. There's things that don't form part of your estate. RRSPs that have a beneficiary, or a pension plan that's already assigned to a beneficiary. Property that's jointly owned. When property is jointly owned, both parties have what's called rights of survivorship, which means both of them actually own the property 100%. And so there wouldn't be, that does not form part of the estate. It automatically goes to the survivor, okay? So that won't be passed down to your inheritors. Any real estate that's jointly owned, not going to form part of your estate. Assets that are dealt with in a shareholder agreement. So if there's a shareholder agreement that talks about what happens with one of the partners' shares in the event of the death of one of them, that won't form part of the estate. Or if there's some sort of trust agreement, or if there's already assets that are being dealt with in a marriage contract or a separation agreement, those won't form part of the estate. Sometimes foreign assets may not form part of your estate, especially if you have a will in the other country, or there's already a regime in that country about how to deal with assets in that country. And there's limitations of a will in the sense that if there's a dependent to your will, like a child or a disabled child that is not being left a certain source, they may be able to challenge the will to obtain more. Okay? There's a few more limitations. The Succession Reform Act, basically I was talking about, you might have a will, but if you have a dependent and you don't leave enough to that dependent might challenge your will. There's a lot of individuals who will, for example, leave more. For example, let's say you leave more towards a son than towards your daughter. If the share that you're leaving towards your daughter is not enough, that daughter could potentially challenge the will, which raises some questions if you're trying to do an Islamic will but somebody challenges it, those are the limitations, right? It's their choice to do that, but it's the limitation that you have on having an Islamic will. Okay? There's also ways for a spouse to choose differently than the will, which makes an Islamic will also limited, in the sense that under the Family Law Act, a spouse can choose to take what they are entitled to under the will, or they can say, I'm not going to take what I'm entitled to under the will, I'm going to take what I'm entitled to under the Family Law Act. And the Family Law Act is what you're entitled to with respect to equalization. So they can treat the date of death as if it was a date of separation, and they do, remember what I spoke about earlier, the net family property calculation. And let's say somebody does the net family property calculation, and under that they're entitled to 500,000, but under the Islamic will they're entitled to 100,000. They can choose to say, no, I'm going to elect to take what I'm entitled to under the Family Law Act. It's not Islamic, but they can do that, and that's a limitation that you cannot really contract out of unless you've got a marriage contract, right? So that's another benefit of having a marriage contract, in the sense that you can discuss estate rights as well. So the Islamic rules of inheritance are pretty clear, right? The spouse gets a certain share, the parents get a certain share, children get a certain share. In Canadian law, like I said earlier, you can do whatever you want to do. But sometimes if you die without a will, what happens, right? Not everything goes to the government. A lot of people say, if you don't have a will and you die, everything goes to the CRA. No, that's not what's happening. There is a intestacy regime. It's spelled out in the law. The court will appoint someone to be your executor. Someone will apply, whether it's your spouse or your children or a friend, and they will have now the power to distribute your estate. Of course, this makes the process more expensive, more stressful, because they may not know what you own, they may not be familiar, and they're kind of being thrown into this responsibility. So I know the chart is a little bit small, but I can summarize it. Essentially, if you die without a will in Ontario, your spouse would get a preferential share, which is the first 300,000. And the rest gets divided between the spouse and the children. So obviously, that's not Islamic rules of inheritance or distribution, because your children have a right, the boys have a higher share than the girls. Your parents also are Islamic heirs if they're alive. So that's completely in contradiction to the rules of intestacy, because the rules of intestacy prefer the spouse and the children only. As if you have spouse, you don't have children, 100% goes to the spouse, which may leave out your other Islamic heirs. That's why more than ever, it's really important to have a will where you actually spell out, I'm going to leave this much to my spouse, this much to my children, this much to my parents, etc. So here is kind of a summary. So if you have a spouse and no children, everything goes to the spouse. If you have spouse, parents, siblings, and no children, still everything goes to the spouse. It says 200,000, but the law just changed. It's 300,000 now. If you have spouse and children, again, the spouse gets the preferential share, and then the remaining is split between the children. Okay? And if you don't have a spouse or children, everything goes to your parents. If no parents, it goes to your siblings. If not, to your nieces and nephews. If not, to the next of kin. If they cannot trace next of kin, that's when everything goes to the government. So there is a hierarchy, but again, none of this is Islamic distribution. Okay? If you want Islamic distribution, you absolutely have to write it in a will and write out what happens. But of course, it's subject to the limitations that I've discussed earlier. Anyone can challenge your will if they're not being given enough, if they choose to pursue the Family Law Act instead of of what they're entitled to under the will, and if there is a dependent. Okay? That's the portion about wills. I also want to focus a little bit about powers of attorney. So remember earlier I spoke about a will only comes alive after you die. Powers of attorney come alive while you're still alive, but you're unable to make decisions because of lack of capacity. So something happened, Alzheimer's, dementia, a coma because of an accident. Anything can happen, and suddenly your capacity is not the capacity that you're at right now. Who's going to step in and make those decisions for you? And more likely than not, people make these powers of attorney at the same time that they make a will, because it's part of estate planning. So who's going to first make the medical decisions for you? Who's going to decide the treatment you follow, pulling the plug or not? Who's going to decide whether you receive a certain operation or not? Who's going to communicate with nurses and obtain information about your medical treatment? That's what we call a power of attorney for personal care. And again, you would list, who would make those decisions. There is already a system in place. If you do not have a power of attorney for personal care, it's your spouse. If not, it's a parent. But you have two parents, so it might create some friction if you don't have a power of attorney about who makes it. Or if you have multiple children and you say, my children are going to make the decision, my medical decisions, it creates a little bit of friction between siblings if they do not agree on the treatment. So it's better to have these powers of attorney already prepared, so your wishes are already clear and set in stone. The second power of attorney is a power of attorney for property. So who's going to manage your finances? Who's going to attend the bank and pay your bills and pay your mortgage and sign off on your refinance and pay for a nurse if you need a nurse, etc.? That is done through a power of attorney for property. And again, it's like giving somebody your credit card, your debit card, the title to your home. And they have responsibility. Of course, there's checks and balances, but it's better to have this in place in case something happens. Somebody can make those decisions for you financially. So that pretty much wraps up the wills part of the presentation. If anyone has any questions, even about the marriage contracts, I'm more than happy to take questions. It's too much, huh? Too much information. Yes, sister, I don't know where the big mic is. Oh, you can project. Go ahead.
All right.
Oh.
Yeah.
She's all...
I have two questions here from before. Okay. So, yeah. So, here, you go ahead.
Okay, sorry. I just had a question earlier. I just wanted to know your opinion about an advice I was given. So I was told to delay the legal marriage, like certificates and everything, and just do your like Islamic marriage first, because I was also told that it's harder to kind of break up the legal marriage contract than breaking up an Islamic marriage contract. So I wanted to know what you think of that, because I know you said like a lot of people do the Islamic marriage and then they wait before they move in together. So is it better to just do the Islamic marriage and the legal, because that's what I'm understanding from you, to like do them together or to preserve your rights, or is it better to delay? I just wanted to know your advice.
Well, nobody goes into marriage and says, how can I get out of this as quickly as possible, right? So I think it's better to be legally protected in any scenario than not to have any protection at all. So if you do an Islamic marriage only, I would suggest at least having a contract that spells out. So even if you want to get out of it fast, at least you have a way and a contract that's going to help you get out of it. But I would not recommend someone not getting legally married just because it takes time to obtain a legal divorce. There are ways, so although a legal divorce takes time, like you have to have a 1-year separation before you can file for a Canadian divorce, there are exceptions to make that go faster. So for example, if there's violence or there is infidelity, you can move out of those contracts, obtain your legal divorce faster. Whether you want to delay getting legally married, I think it's really up to the rights that you're seeking. I think you should not get married if you're not going to have at least some sort of protection about what your rights and entitlements are and what does this new chapter mean. But also, like a legal marriage signifies a certain type of commitment. Like a marriage is not just, let's see if this works out. A marriage is, we're getting married. This is for life, unless something goes wrong. And our marriage contract is going to be our insurance, right? We have life insurance, we have, critical disability insurance, we have all these types of home insurance, fire insurance, pet insurance, business insurance. But do we have an insurance for our marriages, which is the single most important commitment of our life that we make? That's our marriage contract, right? So I would say if you're going to only do the Islamic marriage, at least have a contract about what that means, right? Whether you're living together in a year, it doesn't mean that he doesn't have obligations to you for that year. I think there was someone else in that general vicinity that had questions.
Sorry, I have two questions.
Yes.
I can just go through and you can choose whichever you want to answer.
I'll answer both.
Okay, jazakallah khair. So for the first part, for the second marriage, you mentioned like the wife is allowed to ask that she should be taken permission from before the husband wants to marry. Is that Islamic?
Yes, so I do put that in Islamic marriage contracts. Now, what does that mean, right? Legally, are you going to do anything about that? It's not like the courts will be like, hey, you can't get married a second time, buddy. They're not going to say that because it's already illegal, right?
I know.
But it means, what does it mean to you? So for example, if the husband marries and obtains a second wife, I have the right to proceed with the khula. That could be in your marriage contract, that you have the right to terminate the marriage if he vitiates one of the Islamic agreements that you've come up to. Or you can go and you can make a complaint to the imam, and maybe the imam will engage in a dispute resolution between the two of you and discuss, well, you agreed to this term, how come you're now breaking the term, right? Okay. And maybe there may be some reconciliation, or maybe you will choose to part ways.
But what if it's not spelled out in the start? Like, can she still take khula because he didn't ask? Or it's too late?
Yeah. I mean, if you wish to end a marriage because you feel like this is not something that you can live with, at that point you will have to go. If khula is a process, right? You have to go to the imam. You have to make your complaint. The imam investigates the complaint and determines whether Islamically it's a legal ground or Islamic ground to obtain a khula, right? You can't just obtain a khula for no matter like what reason, right?
Yeah, which is why I'm asking: is this a legal reason? It's like a proper Islamic reason.
I'm not an Islamic scholar, so I don't give Islamic advice, but I'm sure the MNN management has a great imam that can answer that question for you.
Inshallah. The second one is a will question. Sorry.
Yeah, so infidelity, if you can prove infidelity, right? Like if you could get a legal divorce. Remember, the Islamic process is different than the legal process. If you want to pursue a legal divorce, you do not need a reason in the legal divorce. You don't need to tell the court, he did this, so I'm asking for a divorce. You can just say, I want a divorce, period. Right? But if you want a faster divorce, you can say there was domestic violence, and so I'm seeking to obtain a divorce less than the 1 year waiting period, because they won't let you file for a divorce unless you've been separated for 1 year. But there are exceptions, domestic violence or infidelity.
Got it.
You're going to have to prove them, though.
Right. Sorry, just another question about will. If somebody wants to apply the family law over the Islamic law, as you mentioned, they are allowed to do so. Like, at least they can contest, right?
No, it's called an election. It's the choosing to pursue what you're entitled to under the family law it's called an election. So you elect to take your entitlements pursuant to the Family Law Act than what is in the will. It doesn't mean the will can say whatever it wants to say, right? Yeah. The will can say 0 to the wife, right? You can say, I'm going to take what I'm entitled to under the Family Law Act. The will can say 5,000 to the wife. You can say, I can take what I'm entitled to under the Family Law Act, or you can say, I'm going to take what I'm entitled to under the law.
But that's like for the Canadian law, when we're saying we're looking at it from the Canadian law lens, right? But if you put a lens of Islam, and like legally she might be allowed to get more, but because of Islam, she has to have 1/8, I believe. A certain part,
yeah,
exactly.
Yeah.
So if she's saying that if I want more, but that means that she's taking away from the pool of funds, like that should go to other people. So how do you reconcile that?
Well, that's why I mentioned it's a limitation, right? The Canadian will is there. So you can make your Canadian will perfectly, right? And say, this is how I'm going to divide my will. I'm going to leave 50% to 1/6 to my wife, 1/6 to my parents, and 2 shares to my son and 1 share to my daughter. And if the wife says, I'm not happy with that, I'm going to take under the Family Law Act, she can absolutely do that. That's why we say you cannot have a perfect Islamic will, because there's an inherent limitation pursuant to the Family Law Act. Just like if one of your children says, you left me out of this will. I'm not getting enough because I'm a dependent. You shouldn't leave a share to your parents when I'm your dependent. And I need more money. And they challenge the will and the law grants them more. It's a limitation, right? So you cannot have a perfect Islamic will. It could be perfect and everybody agrees to it, but that is a limitation, right? So even if you can make an Islamic will, but at the end of the day, a lawyer will advise you that anyone can challenge it. Yes. Well, they have certain challenges, right? So they would have to bring a claim, they would have to prove they're dependent. It's not like and then there's going to be a ruling of whatever the court decides.
Sister Sabina, how many questions do you think we can take more? Okay, here you go.
So do you know of a list of different imams that one could go to for these kind of questions? Because I'm guessing not
like
all.
wills or?
No, for like if women have to go for khula or that kind of advice.
I'm
like
sure most imams. Yeah. Yeah, I would reach out to your local masjid, and just schedule an appointment with your imam. Imams make themselves available. They don't just sit and do the khutbah and they provide a service to the community. Part of that service is counseling. They do will charts. Like if somebody goes to a lot of my clients say, I don't know the rules of inheritance. I'm not going to tell them. I'm not an Islamic scholar. I can't have that on my shoulders. I tell them, go to your local imam. The imam will give them a chart and say, here are the rules, the percentages for your specific scenario in your specific family. You have this person alive, you have 2 boys, you have 1 daughter, you have 1 parent alive. They'll tell them the percentage. So reach out to your local imam if you have questions about your marriage. Even I think imams are now doing pre-marriage counseling, which is great. Like I would take up these services. They're here to serve the community, so take advantage of that. Look at that, MNN is so high tech. QR code appointments,
And so for POA of finances, is that also once it's what I heard? So can you clarify, when you sign POA of finances, that takes effect as soon as it's signed?
No. These are specific powers of attorney that only take effect when one loses the capacity to make decisions for themselves. So only if there is a medical reason or some sort, like a coma, you no longer have capacity to make decisions for yourself, these powers of attorney would take effect. But as long as you have the capacity, these are invalid. And usually it takes a medical doctor to say this person no longer has capacity.
Assalamu alaikum. I just had a really quick question. What happens if the husband breaks any conditions in the contract? So, for example, if the wife stipulates that her husband should not take another wife, and if the husband breaks this condition, does it result in a divorce or can she annul the marriage?
Okay, so usually in the marriage contract, we will have a section called dispute resolution section. And the dispute resolution section will outline a process about what happens when there's a dispute. Most couples will start off with saying, we need to each try marriage counseling. If not, we need to go talk to a mediator. If not, we're going to talk to lawyers. If not, then somebody can start a court process. So if one spouse, for example, says, you're breaching one, like for example, there's a mahar, it can be paid upon demand from the wife. The wife demands the mahar, the husband says, I don't have the money to pay you, that $5,000 or whatever it is. I can't pay it right now. A dispute now arises. They can go through the mediation, maybe they come up with a payment plan or something like that about how he's going to pay her that mahar. Or they can choose to end the marriage and then proceed their separate ways. You mentioned an interesting word, which is annulment, okay? And I want to talk about the difference between annulment and divorce because I think it's really important to explain. A lot of people say, I want this annulled, I don't want this, like as if it never happened, right? An annulment means this marriage never took place. And there's very, very little recourse, or it's rarely granted. To have an annulment, you need to show that the parties didn't have didn't consent to the marriage, they were under duress, or one party could not have consented, like they were completely drunk out of their mind or intoxicated, or they were underage or something like that, or one person was already legally married and so they couldn't have married, or there is somebody's not able to fulfill the marital acts, like if that is an issue that comes up after the marriage takes place, that could nullify a marriage and have an annulment on those grounds, right? If they cannot consummate the marriage. So it's really late, there's only very few ways to obtain an annulment. More than likely, the marriage will end in a divorce, right? Rather than an annulment.
Yeah.
Yes.
So when